So this is an interesting case that kind of skirts around the issue that it is ultimately about. But it's Burger King versus Rudzewicz. 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 I almost positive that is some sort of a Slavic name, probably Polish or maybe Czech, but I'm not good with those languages. So a franchisee signs an agreement with Burger King that the law will, or any issues with the contract will be litigated under Florida law. The franchisee fails to meet some of their payments, so they get sued. They claim they're not subject to Florida jurisdiction. They have no contacts with it. And so the courts are unclear that if a single contract with a party in another state meets the minimum contact standard. The Supreme Court says no. You have to take into account if the contract was negotiated there, or if it made it clear that you might be establishing contact with it. And the court says that even though the contract says you have to litigate under Florida law, that doesn't matter. It does. It's a factor to consider, but it is not automatic you win. But what does matter is the fact that he was constantly in contact with the main office, which was in Florida. He was constantly sending his payments there, and he was constantly working with and listening to people from Florida and from the Florida main office. So the defendant clearly submitted to a deal with the Florida company that he knew would operate out of Florida, that much of the decision of his franchise would be subject to this Florida corporation. He established those minimum contacts by being in constant contact. Agreeing to the subject of the laws of another state, though, does not mean you have to litigate there. So when the franchisee or franchisor, Burger King, says this will be litigated under Florida law, that does not mean that the suit has to happen in Florida. Now, that could happen in a federal court in Michigan. Now, that would be inconvenient for the Michigan federal court, who knows Michigan law, not Florida law, super well. Doesn't matter, though. Ultimately, they're going to be subject to Florida law in Michigan, even if the case, but unless there are minimum contacts, which there are going to be, especially in this case and most similar such cases. So yeah, generally speaking, if you're working with a corporation that's got its, headquarters in, say, New York, and you live in, we'll say, Pennsylvania, they can sue you in New York if you've been in constant work with that company and if you've constantly been maintaining contact with people in Florida and making deals with people in Florida, signing contracts with people in Florida. That would subject yourself to the minimum contact standard, even if you don't have any place of business there or employees or anything like that. There was a dissent. Used a very fun term. His burgers and milkshakes were not made in Michigan, intended to go to Florida. That doesn't matter. He was making business dealings with a Florida company and constantly making business dealings with with the same Florida company. All right. I hope you all have a good night, and probably post some more videos next time. Should be tomorrow. I don't know. We'll see. Y'all have a good one.